Now, I have a few questions for you. There's no right or wrong answers, so I'm just trying to get a sense of what you all think about probate. So the first one is probate, and just raise your hand. Is probate a good thing or a bad thing? So how many think yes, good thing? How many think bad? Okay, more bad, okay. Should I avoid probate? How many would say yes, I should avoid probate? Okay, most of them. How many say no, I shouldn't avoid probate? Okay. If I avoid probate, will I save money on taxes? How many say yes? How many say no? How many don't care? Oh, okay. Okay. If I avoid probate, will my heirs save any money? You think yes? How many think yes? How many think no? Okay. All right. Well, I'm not going to tell you any answers. No, I will. I'll get to it. It'll just be a little while before I get to it. So I'm going to go through a few other things, but generally the answers are often, it depends. It's not always a black and white answer, but what would you expect from lawyers? Of course they're going to give you an answer like that. Now, unless you can figure out a strategy to obtain eternal life on earth, you're going to have to eventually face probate, or your heirs are going to have to face it. So what is probate? Well, probate is the process of supervising the transfer of your wealth to your beneficiaries if you have a will, or to your heirs if you don't have a will. But it does provide an independent arbiter who will try to make sure that your wishes with regard to your estate are actually carried out, which if you have nobody looking over your heirs' shoulders, that might not happen. So that's, is that good or is it bad? Well, it really depends on the character of your heirs and your beneficiaries, whether they get along, which is what Alyson was talking about, and whether you've made all of your wishes as clear as you possibly can. So now what kinds of probate are there? Well, there's testate probate. That just means that you have a will, so it's testate. There's intestate probate. That means you don't have a will. You died without a will. So which one is better? Well, I can finally give you an answer. It's always better to have a testate probate, to have a will that says what you want to happen. Now, I suppose as a partner in a law firm with a very substantial trust and estates practice in the area, I should maybe encourage you to leave a mess for your heirs, because then we'll have more to do eventually. But we don't want that. What we want to do is to solve your problems in advance, try to minimize the problems that are going to happen afterwards, and that's our job, we feel, not to clean up afterwards, but to try to fix them in advance. Now, if you learn nothing else this evening, two things: have a will and make it clear that it's what you want, and try to keep it up to date to state what it is that you want. Now, if you don't have a will, what's going to happen to your assets at your death? Now, if you have a spouse and you have children, the first $100,000 goes to the spouse. The balance gets split 50-50 between your children and your spouse. That's if they're children of the surviving spouse and the decedent. Now, if it's a second marriage and they're children from different marriages, then from the first dollar, it gets split 50-50. Now, that's if you don't have a will. Now, since they said I was old, I've had a lot of clients over the years, and of the thousands of clients, I've never had anybody say that's what they want to do, have it split 50-50 between the spouse and the kids, or the first 100,000. So just keep in mind, if you don't have a will, that's what's going to happen. Now, keep in mind also that it's also just your probate assets, and your probate assets are assets that you own solely in your own name. So if you have joint accounts, if you have beneficiary designations, if you have POD, payable on death accounts, any of those things, those are non-probate assets. They pass according to the terms of whatever the agreement was that you made, the joint asset agreement. So those are outside what I'm talking about. Now, in some cases, if you don't have a will, that's what's going to happen. I think most of you would prefer to give your assets to your friends or a charity or your children or whoever. I mean, your children are going to get it under that scenario, and your spouse, but it might not be what you really want. Now, I'm often asked if an heir who is left out of the will can contest the will. What can they do? Well, anybody with an interest in your estate has the ability to contest the will. Now, are they going to do it? Most cases, no. And the reason is that it's going to be expensive and they're probably going to lose the matter. So I also get calls from outraged relatives on a fairly regular basis saying, how could I have been left out of the will? Well, when I started out as a probate judge, one of my first cases, a relative showed up. He wanted to know why he'd been left out of the will. I asked him one simple question. When's the last time you saw the decedent? Oh, it was 10 years ago. Well, I think he just answered your question for you. But you, basically I tell them, if you want us to look at the case, you probably need to send me $10,000. I'll look at the case and then I'll tell you have no case. Because it's very difficult to bring an action against a will. Now, there are bases for doing that, but the chances that you're going to win in a case like that, if you're trying to contest a will, are, if not zero, they're getting close to zero. But as an attorney, we don't want to take cases that we know we're going to lose. One, we're going to have a very unhappy client, which we don't like. We want you to all be happy. How many of you are happy? No, I'm just kidding. I'm hoping you are. But they're going to blame us for being incompetent, or they're going to say we're conspiring against them in some fashion. So it's always a bad thing to take a case you know you're going to lose. But having said that, we have taken cases on both sides. And we do have several probate litigation attorneys. They're not presenting today because they're a subset of our Trust and Estates Department. There's Frank Cinto and Tim Herring. Tim's here. There he is. You want to say wave? There he is. Now, he's a litigation attorney, so he should look mean. But does he look mean? I don't think he looks mean, does he? He's a nice guy, so despite being a litigation attorney. And Frank Cinto, who is participating in his church's ministry this evening, couldn't be here. Now, the anecdotes that I've got really are, we took one case where we were attacking the will, and we actually managed to hit a home run, despite what I just said, which is we usually lose these. We had the usual arguments, which we had a witness close to the date of death who said that the decedent wanted to leave money to this particular person. We had other witnesses who said that the decedent was encouraged to leave the assets to particular people other than our client. Our client happened to be closer in relation to the decedent than any of the other beneficiaries, although that doesn't really matter as a matter of law. But eventually we managed to convince them that it wasn't fair. The other side decided it wasn't fair, and we managed to get a settlement on behalf of our client, but that's an unusual circumstance. In another one, we were defending the will, and the party that was attacking the will had evidence. It was old evidence, fortunately, that the person was perhaps at that time not competent to execute a will. But it doesn't matter what happened 5 years ago or 10 years ago. What matters when you execute a will is whether you're competent at the time you executed the will. So we did an investigation. We found evidence through doctors and a lawyer that he'd met with that we had a strong case as far as competence of the person. So they tried to negotiate with us. We said, well, we'll negotiate for defense costs. It's always going to cost you money if you're defending a case, and why not give it to the other side and get a sure answer as opposed to taking your chance with litigation, because you never know, even though no matter how great your case is, you never know for sure whether you're going to win or lose the case. But at any rate, they wouldn't take it. We won. They got zero. And the gentleman who was the plaintiff, of course, got nothing, plus he had to pay his attorneys, I'm sure, quite a bit of money. Now, there's two bases if you wanted to contest a will, and that is lack of capacity, which I was just talking about. Were you competent at the time you executed the will? or undue influence? Did some third party substitute their judgment for your judgment? Now, lack of capacity, and I'll read it to you, is whether you had a mind and memory sound enough to know and understand the business upon which you are engaged, that of the execution of a will at the very time you executed it. Another way of putting it is whether the signer's mind and memory is sufficient to know that they are executing a will, have some idea of their assets, know the natural objects of their bounty, understand how they wish to distribute their assets, and be free of undue influence. Now, natural objects of your bounty means, do you know who your relatives are? Do you know that you have kids? Do you know who they are? Can you recognize them? That sort of thing. You don't have to be perfect, but you have to have a general idea of all those things. And as I mentioned, undue influence is when someone else substitutes their judgment for yours. Now, what would be a typical case? Well, you've had wills for years, you've left your money to your kids, you get older, you get sick, you hire a nurse, the nurse comes in, 2 months later the nurse gets half of your estate because they changed the will. Well, that's likely to be an undue influence case because it's a person in a position of authority over you and they suddenly become a beneficiary of your estate. So those would be cases where you could win because you've got undue influence. And if the person is completely crazy, you could win the case there too for lack of capacity. Now, back to my questions, which I said I would try to answer. Do I want to avoid probate? Well, the answer really is you can't avoid probate. No matter what, you have to file a tax return with the probate court. So if you have 0 probate assets, you still have to file a tax return with the probate court. It's based on the federal tax return, so it means all assets, wherever located, however owned, go on your tax return. You file that with the court. And you have to, if you have real estate, you have to obtain a lien release because you're not going to be able to sell the real estate unless you get that lien release and record it on the land records. However, you can limit what you have to do. So if you have a surviving spouse and your assets are less than $3.6 million, that's today, a couple of months it's going to be 3.6, what is it? It's 5.1, right? And then the year after it's 6.1. So Connecticut is getting to the point where it's competitive with most other states in terms of estate taxes. Most of us are not going to have any estate taxes anymore, either for federal or for Connecticut purposes. But if you make everything joint, and you have your spouse as a beneficiary of all your assets, you can basically have no probate assets and no probate process. So you file a tax return, get the lien release, record the lien release, and that's less work in that case than having a full estate. And you might want to consider that. There's reasons why you might not want to consider it too, but I won't get into all of it. In that case, you file the will for informational purposes because there's no assets passing under your will. And you file the tax returns called a TPO, or tax purposes only estate. And once you file that, you pay the probate, called a statutory probate fee, and you're done. Now, what's a statutory probate fee? Well, that's required by the statutes. It basically is used to support the probate court system, and it's 0.0025 up to $500,000 in probate in assets. Or 0.0035 for the amount between $500,000 and $2 million, and that covers most of the estates. And then it goes down if you have a bigger estate. So if you're a spouse and a surviving spouse, or decedent and a surviving spouse, the assets are joint. They're split 50-50 for purposes of calculating the fee. So now we're already at 50%. And then there's another rule that says if an asset passes to a surviving spouse, it gets reduced again by 50%. So essentially you're looking at 25% of the total value of the assets for purposes of calculating that fee. And as I said, it's 0.0035 or 25. So it's usually not a big, huge number. It's not like a tax at all. It's more of a fee. Now, the next question I asked was, will avoiding probate save you any taxes? I think a lot of you said yes. Well, the answer is no. It's not going to save you anything because, as I said, you're going to file a tax return anyway. And if you have a taxable estate, it's going to be taxable whether you go through probate or not. You can have a multi-million-dollar estate and you can have zero probate assets. It's still a multi-million-dollar estate and you're still going to pay the same in taxes if you're taxable. But as I also just said, a lot of estates are no longer taxable. Now, will avoiding probate save your children any money? Well, the answer is maybe yes, maybe no. In the TPO estate that I just described to you, yes, you're going to save some money because there's going to be less work to do, and therefore you're going to pay less in legal fees to help you get through the process. Now, my experience with trust, and particularly those that are promoted by free seminars around, I guess we're a free seminar, but we're not promoting them. And I hear they're charging $6,000 sometimes. It really doesn't, in most cases, doesn't really do much for you. They promote them on the basis that you're going to save taxes. Well, you're not going to save taxes. They'll promote them on the basis that it'll save you time, effort, and money, but that generally is not true. For most of you, I think the aggravation of trying to retitle all your assets in a trust is, it's a lot of work. But there are really valid reasons why you might want a trust. If you want one to manage your assets and to keep it in the trust, it also is helpful in increasing the amount that's going to pass to your children tax-free. Those are all valid reasons, but I'm not going to get into all of that right now. I'm also often asked, well, I want to transfer all my assets to kids now. And my answer is always, I don't think that's a good idea. You ought to control your assets. You ought to preserve them for your own betterment and for your health. It's expensive these days, as you know, if you have health problems. Now, again, I'm not getting into Title 19 issues. This is just for people that have sufficient funds. I don't really think you should be giving them up to give to your children. There's also some adverse income tax consequences. If you give an asset away, the person who receives the gift takes the tax basis that you have. So if you're giving away an asset with a low tax basis, the person receiving the gift takes the same low tax basis. They turn around and sell the asset. There's going to be a capital gains tax on the difference between that low tax basis and what they sell it for. If instead you die, I'm not recommending you die, but if you do, you're going to get a step up in the tax basis to the date of death value the value of the asset at the date of death. Therefore, when your heirs turn around and sell it, there's no gain because we no longer have the low tax basis, we have the stepped up tax basis. Now there's been discussion of doing away with it, but so far as I know, that's not going to happen yet. Now, what can I do to make the estate easier? How am I doing on time, by the way? I'm not keeping track here. So when I get to 20 minutes, you start booing and I'll know, okay? So another question is, what can I do to make it easier for my children? Now, obviously, one is have a will. Number two is make your wishes very clear, what you want done. Tell your executor what you want. You know, for example, funeral arrangements. Do you want to be cremated? Do you not want to be cremated? Do you want to be buried? Where do you want to be buried? Do you want a church service? Do you not want a church service? It makes it a lot easier for your executor to carry out your wishes. If you wanted to be cremated, you can do what's called a self-directed cremation permit. You can appoint somebody who will have the authority to do that if that happens to be what you want. I also generally suggest that you create some kind of a financial statement for your heirs so that they know exactly what your assets are, where they are, how they're owned, whether there are any beneficiaries to them, and also what your debts are so they can track them down relatively easily. They should know what sources of income you have, which are usually pensions, perhaps, Social Security, required minimum distributions, whatever it is, rents, whatever it is that you have. it's helpful if they know what those assets are. I know I've had a number of estates over the years where I knew nothing, and we had to spend, one case, several weeks in the house going through every piece of paper. We get the mail, we go through every piece of mail, we try to get the tax returns, we contact the IRS, we look to see what all the dividends were, we have to track them all down, all of which is a lot of work. So if you write it all down in advance and tell people, it's going to be a lot easier. Now, I think I have probably exceeded my time. He's saying yes. Well, nobody booed, so okay, I'm all right. So I'm going to introduce our next speaker, which is Elizabeth Hartery. She's a graduate of Yale University and the University of Virginia School of Law. She is one of our younger attorneys, and as you just noticed, I'm one of the older attorneys. And but she's an excellent attorney, and we're very glad to have her as part of our firm, and I'll turn it over to Liz.